You're in tune with the voice of Ghana. The time 21 hours, 14 and 30 seconds. Good evening to you and welcome to tonight's edition of The Police and You. The name is Stan Govaya, Mike Side, keeping you company as is usual this and every Tuesday night, where we, of course, give you a chance to be able to interact with various departmental heads and also those commanders of various divisions. And we do ask that should you decide that you're going to call, you've got a question that you've got to ask of our guest, you keep it to the discussion at hand and the portfolio of the person we've got. Of course, at this time, it gives me great pleasure to introduce Woman Assistant Superintendent Shavon Jupiter, who is the Court Superintendent for Regional Division 4C. A very good night to you and welcome to Police and You, finally.
Good evening to you, sir, and thank you for having me.
All right, so let's just start off when we say Division 4C. Uh, to let persons be able to wrap their heads around that and to understand a little bit. What area does this span? And since you are the court superintendent of that division, tell us also about how many courts are located in that area.
Well, basically, the Guyana Police Force has been subdivided in accordance with the regions of Guyana. And as such, Region 4C falls within the ambit of Region 4. But it covers the coastal division, so that'll be basically on the east coast. And it ranges from the Arch, which is located at Industry, and it ends currently at Mahaika, the bridge at
So from the
Mahaika.
arch all the way to Mahaika,
Yes, sir.
that's on the coast. And
Yes.
how far back would you say that it goes in terms of cover? Backlands
It's
are like some of those areas, like the
yes,
Pleasance, Mahaika.
they cover a number of areas, and it even covers the St. Cuthbert Mission. Yes, and we
So
have
all the way
some
to St. Cuthbert's Mission, that we would know that you could perhaps take the route to go up the
the
highway.
highway. Yes,
And yet, okay,
that also falls within our ambit.
all right. And so within that area, how many courts would you say that you have that fall under your supervision?
We currently have 5 courts falling within Region 4C, ranging from Sparendam to Mahaika. At Sparendam, we have 2 district courts. At Vigilance, we have 1. At Coven John, we have 1. And at Mahaika, we have the next one. That will be the final court.
Sparnam, Vigilance,
Coven John
Cove and John.
and Mahaika. But at Sparendam, there are 2 courts because of the span and the number of matters we have coming in. So there is Court 1 and Court 2. So that accounts for the 5.
Quite a lot of courts you've got under your belt to deal with, and a number of obvious matters that you would have to deal with on I would say daily basis. So this is definitely a huge responsibility and role.
Yes, it is indeed. It used to be more extensive in that we used to cover Maikoni at once, but now, so I had 6 courts under my belt. So now the responsibility is a bit diminished, so it's only 5 now.
All right. So as we continue, I want to know. You are a prosecutor, but you are the court superintendent, and it therefore means that there are lots of prosecutors that come under your purview. For persons to understand, what is the role of a prosecutor?
Well, there's 6 prosecutors currently under my control, and their role vary Their role is much similar to that of a state attorney or district attorney that we would normally know, but their role are more or less quasi. It's similar to that of the attorney. But what makes it different is that we're trained in a different way than the attorney. Their testimonials are far more formal. And if you want to say ours are a little informal, meaning that we weren't legally trained by the university or such. Some of us have university degrees and stuff, but it doesn't necessarily fall under the ambit of law to complete the entire structure for what is needed in order to cover the LLB and among other credentials. Some of our roles entails the perusing of files. The reason why we peruse these files is to establish elements of various offenses. And the elements of these offenses fall within the laws of Guyana on the criminal law, because our law basically covers the criminal aspect. And we would normally present these cases in court in a manner that is contrary to law and contrary to procedures that we ought to follow that is set out by the judiciary. So we would present those cases according to the facts that comes before us with the necessary elements, and we will also look for the statement of the offenses to see which category that offense fall, whether it be summary or indictable, and what are the necessary elements to prove those offenses.
Now, you just mentioned two things there that are quite interesting, and I'm sure for the benefit of persons who are listening and even watching, we'll talk about that just now. Summary and indictable. Lots of people, because they've never had issues with the court, they don't have a clue. All they know that, okay, they were arrested or charged, but they don't know what it is. Give us an example of maybe what is a summary matter and what is an indictable matter.
Well, just in layman terms, we would normally say the higher offenses and the lower offenses. The higher offenses is linked to the indictable matters, and the lower offenses, which can also be determined as misdemeanors or summary offenses, are the lesser offenses that they may bear a lesser penalty. It might not necessarily be imprisonment. But the indictable ones, sometimes they're of a nature that you might be in prison once you're found guilty of that offense.
So, for example, let me see if I'm smart enough. So, like currently, COVID breaches, those are you call summary offenses.
Yes, those are misdemeanors. So there'll be no imprisonment time, but there'll be a fine attached to that, and the fine is $16,250.
Cuss out with a neighbor.
All of that are
To keep the
determined.
peace or something like that. Those,
Yes, all of that are determined as summary or lesser offenses.
all right. But then when we get to the serious things, you damage somebody, you hospitalize someone. Um, as we would call it, serious wounding and those kinds of things.
Yes, we call it felonious wounding. We have wounding, and well, the felonious will be the higher of the set. The wounding will just be common, and it depends upon the nature or the magnitude of the injury. Then we will categorize those offenses as into whether it's serious. Serious will count for life-threatening.
All right. Interesting. Of course, in case you just joined us, this is Police and You, and we have on tonight's program Ms. Shavon Jupiter, who is woman assistant superintendent, and the court superintendent of Regional Division 4C, all the way from the Arch on the East Coast to Mahaika. And we're discussing the issues that fall under her purview and the matters of the court. You can, of course, follow the conversation on our Facebook page, the Ghana Police Force. You can also tune in also through the live stream on VOG's 102.5 FM. If you've got a call particularly related to any court issue in the Regional Division of 4C, you can give us a call on 226-4762, or you can send your question via WhatsApp on 6320147. That's 6320147. Assistant Superintendent, now there's something called oath, and then there's something called affirmation. So, walk us through why this is important when giving information.
Well, the oath and the affirmation is very important. It dates back a few millenniums back into the Anglo-Saxon. So that'll be the English hemisphere, Eastern hemisphere. And they believed back then, millenniums ago, that telling the truth was very much important. Hence the establishment of the oath and the affirmation. During that time, the oath and affirmation, it accounted for any crime. However, persons were responsible for crime during that time as young as 12 years old. But then it went on to increase for criminal liability at 16 years old. So they believed at that time that the oath and or the affirmation was simply a form of getting the truth out from somebody for any wrongdoing that they would have committed. And the oath was basically a solemn, sworn, basically, and it was linked to the religion because in those times people were very religious. The religious realm at that time was our courts. And the affirmation was more or less of a pledge to be truthful, but it wasn't linked to religion. So you had the opportunity then, and you have the same opportunity now, to choose between an oath or an affirmation. The oath linking to religion because it's solemn, and the affirmation linking to a pledge. So you can either swear before man and God to tell the truth, or you can affirm, which excludes the man, the God, but the man remains because everybody's there to listen to you utter the truth.
Oh, so that is where obviously when that person's going to go into the box to, as we say, testify.
Yes.
Before they do, they either on one hand on one of the holy books.
Yes, sir.
They then give the oath.
Yes, sir.
If it is that they choose not to, then they affirm.
Yes. So with the elimination of the religious book, so you hold your hands up and you take that oath and you bear witness before whatever religion you believe in by holding the Bible, the Gita, or the Quran, according to the Guyanese religion and any other religion that we are able to facilitate.
Awesome. Now, I'm sure it's not going to be judgmental, but yes, I'm sure. Do you find that people take the oath and the affirmation very seriously? In modern times, you did mention in the Anglo-Saxon times when this originated, religion, out of which it was birthed, was the kind of court system that people had. So they very much revered those things. But do you find that in some cases some people can easily decide, well, they're going to either take an oath or affirm to tell a lie or upon a lie, as they call it sometimes?
Well, that do happens, but it's not very often. And there are ratifications for every action that we take. And basically, when that happens, persons are untruthful to the court, although they would have sworn or affirmed to tell the truth and they deviate from that. there are penalties to pay. When somebody does or they're untruthful to the court, it's called some level of perjury because we're lying and we swore to tell the truth. So when person are perjurous, more or less, they suffer the consequence of the law where they can be charged criminally for perjury and they can spend time in prison, so they can be detained and they'll spend time in prison for up to 5 years. And if it is that the judge is lenient to pardon you because you literally made a mistake and then probably you accept your mistake thereafter, they can not confine you to any time in prison, but they can think about giving you a general fine in terms of money. Or you can suffer some level of detention, community service. It depends upon the magnitude of the lie you would have spoken of.
All right, quite interesting. Now, another thing that people hear a lot and they're not sure how many there are, but I've been told that there are several, is when you hear the term warrant. Oftentimes you hear, "Yeah, I got a warrant out for you, boy," or "Here, there's a warrant out for you, girl." It's usually arrest. But there are different types of warrants that are actually out there. What are some of these types, and under what circumstances are they issued?
Well, warrants are issued basically by the judges or the magistrates in the various types of courts. And they basically are highlighted in the Police Act 1601, and they're highlighted in our Summary Procedure Acts. So there'll be our Summary Procedure Acts, and they are found in 1002. So those specifically speaks to warrants. Warrants are of many types, like you mentioned, but our law in Guyana, we focus basically on three types of warrants. That's a search warrant. We focus on the arrest warrant. We can also call it the commitment warrant. Search sometimes also count for seizure warrant. And then we have the affiliate warrant, which is called affiliation, or some people also term it as maintenance warrant.
So when you're talking about maintenance, we're talking about maybe like taking care of a spouse, taking care of a child, those kinds of
Yes,
warrants.
those kind of family situations in terms of being responsible for whatever you have to do in terms of making sure your family is comfortable, food is provided, basic needs are provided. So the affiliation warrant helps to support that.
In your jurisdiction, out of the three main that you give, which would you say are the most dominant ones that you see being issued?
That will count for both the arrest warrant and the affiliate warrant. We don't have much of the search warrant unless it's absolutely necessary. And we need to gain entry into property or to seize property, then we will go in that direction.
You know, it's funny that you did mention that, because I think just recently we were seeing on social media sometimes police are going to effect arrest, and you're hearing people start to video, for example, and they're making statements. Where's your you don't got no warrant to search this place? How come you're coming in here, sir? But the police went to make an arrest. But they subsequently searched and they might have found something illegal. And you're hearing lots of those social media postings that the videos that they put up, that it was illegal that they would have done or so. Um, any comments or thoughts on that?
Well, no search will be determined illegal unless something illegal happens upon that search, because the law makes provision for us to search with or without a warrant upon probable cause. And probable cause meaning something was reported, there's some level of suspicion So we act upon whatever is reported or whatever suspicion we may have.
All right. Probable cause. This is, of course, Police in You 21 Hours 34. We've got the Court Superintendent of Regional Division 4C on tonight's program. That is Assistant Superintendent Shavon Jupiter. Now, I want to turn my attention to ever since the pandemic, one of the things that has happened is that in order to keep persons safe, we've seen a lot of the virtual platforms, including Zoom, being used to conduct cases. Tell us how this has impacted the volume of cases that you have in the courts. Would you see it as a plus? Is it, even if it is that after the pandemic you will keep this because you feel that you can have more done, or is it a little bit more burdensome and a little more difficult?
Well, the virtual platform basically has its pros and cons, like everything else. And we have many pluses, we have many challenges. And some of the challenges are equipment wise, it's more or less technical. And because of the pandemic, there's been a numeric alteration to many of our cases so as to avoid a large sum of persons appearing at court or at any virtual setting. Hence, the force would have made provision for each division to have virtual courtrooms. These rooms were equipped with computers, speakers, internet access in order for us to gain access to the magistrates from across the board. So we can access them from any point, at any place. However, we are going, like I said, by a numerical system. And that system in my division, we are just allowed to approximately 25 matters per day because of the pandemic, whether we're doing it virtual or normal. But sometimes it's safer to do it virtual. But sometimes we have malfunction with the equipment, and the persons sometimes they might be suffering various hearing impediments, or not necessarily an impediment. It might be a technical
Glitch.
problem.
All right.
Yes.
But you would say that it
Well,
has more advantages with the virtual.
in terms of being safe, and it helps us from traveling because, like, see, the vision is very wide. So, like, I remember doing a virtual setting in the back of a court trial in the back of a police vehicle, because at the time one of my prosecutors, she was ill, and I had to scurry way up to Mahiko. So I was there and I am presenting in the back of the vehicle while I'm on the cell phone. The lawyers can see me, the magistrate can see me, and I would have gotten information on the case, like facts and whatever is needed for me to present at that level. It came to me via WhatsApp. So it was very helpful. So by the time I got to Mahiko, it was with no need for me to be there anymore, but I was just there in person, so I could actually physically write in the case file because I didn't have it. I had pictures of it.
Okay. And this kind of most likely I'm sure speaks to the way the world is going, not just Guyana, but other countries where a lot of these kinds of situations are being adopted. And I'm sure you would want to say that we can have this kind of hybrid situation even after coming out of the pandemic, where you've got the necessary in-person cases, and for exigency purposes, make sure that we have our virtual platform. Would you agree with that?
Yeah, I would agree because let's say that a prisoner is sick and he or she can't make it out of the prison to come to court. We can have the virtual setting. We can do it for various purposes, like for children, avoid exposing them to the legal system and them coming to court and being afraid, among other things. They can literally stay home. Password will be sent to their parents, and the parents are right there with them, right? But we will have to be able to see everything that's happening so there's no trickery behind the cameras.
I like that. I like that. Let's turn our attention right now to an actual trial that is going on. If someone is accused and therefore before the court, can they then request a change of court for the trial? And if so, what is the procedure? You know, for some strange reason, let's just say, what it is that that person feels, you know, in some cases, now boy, it look like I ain't get sink because this prosecutor really, you know, helping me, or these people got too much of a name, or I don't like this magistrate, or whatever. Is there any, you know, uh, option that they would have that they could request a change of court for their trial?
Yes, but it just doesn't happen like that. I just don't like someone and I want. There must be some level of unfairness that you see that is going to be portrayed against you, or some level of impartiality. So you have to bring it to the authorities' attention by way of a motion or by way of an affidavit through your counsel, whether you're represented or not. You can take the action yourself as well. Just to write to say, well, I'm uncomfortable because of the above reasons, right? There was a problem prior to now, and it has to be a legitimate reason. It just can't be disliking someone for no reason. You have to bring your proof that I am of the opinion that a fair trial will not be meted out for me as in a specific court, and hence I'm filing this motion or this affidavit to move to a next court. And then we have to take into consideration jurisdiction issues. And then it just doesn't happen like that. The chief magistrate has to veto same based upon what you would have delineated in your motion or your affidavit.
All right, so there's procedure. You just can't, a person just can't up and say, well, I don't want it in this court anymore.
Yes.
Right, there are procedures that have to be followed. Certainly hope those who are in tune, you pay attention and you get the answer to that. Now, but if a person, what about a person who is unable to retain legal representation? Particularly in the case of them being accused, they're the accused. Um, what options are there for them?
Well, the court can proceed whether you're represented or unrepresented. Whether you're represented by a formal attorney or you choose to represent yourself, provisions are made for that. However, you can apply if it is that you cannot afford legal representation. The state makes provision for that as well. So you just need to follow the right channels in order to have somebody represent you free of cost. And if it's on the other hand, you might be paying, or you can just be representing yourself. So you listen carefully to whatever the court dictates and you answer in accordance. You ask questions that are logical or that are pertaining to your case for yourself. You make copious notes if necessary. So you're granted the same opportunity that your attorney would be given if you're represented. Unrepresented, same leverage. You ask your questions in relation to the case, however you know it. You don't have to be formally trained, but sensible, asking things in a chronological order, and putting whatever it is out there to the magistrate. And if it's not correctly directed, she will also assist you to ask the witness whatever it is you intend.
Let's now flip now to if it is that it's a victim or a virtual complainant, as we know. And usually the victim or the virtual complainant is represented by the prosecutor in the matter. If that virtual complainant somehow decides, well, maybe whether it is that they assume that this is going too slow, or they feel that the accused has a hotshot lawyer, and they don't feel that they're gonna get justice, they're gonna lose the case. can they or they ask for like legal representation besides the prosecutor?
Yes, they can. If they have their attorney, they can work in tandem with us, the prosecutor, if that's their desire. So it'll be a half and half representation, but yet still the prosecutor or the prosecutor speaks. So the attorney will channel what it is that the client is asking of them to us, and we still present, but we do it side by side. If it's not that way they're asking of it, and they're asking of it in the next way, the attorney can apply for a fiat. A fiat basically comes from the Director of Public Prosecutions, and it's directing the court basically to do a specific action. A fiat basically is a Latin term, and it means to be done. So that document will direct the court that this person will not be represented by the police prosecutor or the state prosecutor, but their own private prosecutor has chosen.
Okay. Or if it is, as you mentioned, the first part where they go half and half, but uh, the prosecutor, everything is
Speaks.
channeled through the prosecutor, who will basically be the lead.
Yes. And
Awesome.
even when the fiat is granted,
Uh-huh.
sometimes we still work together because we would have had the case for some time and we know it by heart. So the lawyer come in, on, and there's not enough time for him or her to brief himself or brief herself. We would update them on what information is in the file. They'll have a chance to peruse it for themselves as well. But being that we had the case for some time, we know it by heart, and we'll be able to offer some assistance, even to get witnesses, summons, whatever it is, because it's still a state case, despite a different channel of representation is being put forward.
All right. One of the things we see oftentimes, prosecutor, is that in some cases, by the time a matter gets a hearing at court, you hear from a victim that they wish not to proceed with this matter or they wish not to give evidence um, because they would have reached an agreement in some cases with the accused. What happens then?
Well, when there's an agreement, we normally give a NFA statement, no further action, and the investigators, they accommodate that process. They will bring it to our attention by way of the complainant, or if they have the information, and we will contact the complainant to verify same. We invite them to give the NFA statement, and we still take it towards the court because we don't have any authority to settle or anything out of the court. Everything has to go to the court and the magistrate decides. But we will make it knowledge to the court that he or she indicated that they wish not to proceed with this matter, and they would have given a statement, or they would have had an agreement outside of court. So sometimes they would have gone to their private lawyer or commissioner of oath or justice of peace, and they would have drafted up a little agreement between themselves. So we use that as part of our case to put it within the file and to present it to the court. If it is that the matter is so grave that we are undecisive that this is the way we should go because there might be a travesty of justice, we will send our file for advice with whatever information, the NFA statement and the agreement, if one is available, and we send it for further advice to the DPP office, and she directs on the way forward if we should completely withdraw because there might be some level of doubt that justice might not have been equated on both sides, or whatever is being offered, it might be unreasonable. It's not for us to decide, but we'll take the whatever information is provided and we channel it to the authorities who will therefore advise us on the way forward after.
You talked about if some of the maybe more serious cases, and I want to like point out let's say specifically examples. Let's say it's a matter of rape, or it's a matter of a sexual assault. Will the complainant and the accused reaching an agreement, and the complainant particularly saying of their own free will in court that they wish not to pursue this matter further, will it then nullify your prosecuting of that matter? Even if it is, you've got all the evidence that this person can be prosecuted because they committed the act.
Well, especially if it's a child involved, we would not go forward because that child might be coerced by a family member, a parent, or whatever, and they might be looking at that child's future in terms of protecting them or whatever. Whatever the reasons are, or I don't know if a compensation would have been offered or whatever the reasons are, we wouldn't take that chance. If it's a grown adult, we always try to go according to the rules, and the DPP must advise on certain matters, especially matters of an indictable nature. So if it's an attempted murder too, and there's a stab wound to the neck, but the person survived that stab wound, it would have been an attempt on that person's life because it could have injured a major artery or vein or something to that extent. But yet still they're able to salvage that case by other means outside of the court. We will still need the requisite advice, because let's say that person dies sometime later of that said stab wound, because murder is still established, and it goes on to up to a year and a day of you being hurt by someone, and you die within a year and a day of being hurt by that someone, the offense still stands.
And that is what so maybe not to bring in personal views, but would you say that some of the legal writings would consider deals between complainants and accused in very serious issues like this, uh, that kind of like ties the hand of the state prosecutor, you, from going forward, would be a travesty in justice? Are there any scholarly writings that point in that direction, you would say?
Well, in some aspects, and even it doesn't even comes down to scholarly writings or whatever. Sometimes the magistrate, in his or her own sense, they would reverse that decision. They would be in the sense that prosecutor, prosecutrix, are we serious here? Someone is hurt, a child is hurt, or whatever. And if the advice come and they say not to prosecute or to discontinue the charges, we can't go against that. But if it is, we're dealing with it in court, and the magistrate is there, and they're asking to, we call it NEO matters. NEO meaning no evidence offered. And you're choosing to go down that way, and the magistrate thinking, no, this is too much, this is too severe, he or she reverses the decision. So even if the prosecutor is saying that we're in agreement, if they want to settle, we don't have a problem with it, they, in their own sense, they will judge the case upon the merit that is presented, upon the injuries. They will view the medical report, among other things, before they take a firm decision.
Quite interesting. Now, in your jurisdiction, would you say you've had any circumstances, and if so, what would allow for, let's say, what we call the rearrest and maybe recharge of any person or persons where the matters have been dismissed? I can recall we would have had some incidents where persons at various levels they had the matters dismissed, but then there was rearresting that happened. Have you ever had in your jurisdiction any such matters? And if so, what kind of circumstances would lead to that?
Well, some of the circumstances will lead for new evidence arising in the case while the person was dismissed. But however, the only thing that we can do to have that person rearrested, if there's new evidence surfacing, it will be in terms of launching an appeal. And we have a specific time in which we need to do so. And an appeal, we have a 14-day period in which we can rearrest and recharge. We also have to look at certain conditions in terms of the ambit of the crime, and we have to look at things like if the Administration of Justice Act was applied, because in some cases we have a matter before court and yet still the prosecutor or the prosecutrix does not apply the administration of justice because we feel that we are not fully ready. So we ask for some more time. The case is still legitimately before the court, but we ask for more time. So if something goes wrong and the AJA is applied, we have to go through a formal channel of launching an appeal. If no AJA is applied, we can always reinstitute the charges if it is not dismissed or discharged for some reason unknown at this time or some reason that would have been judged by the magistrate or whatever it might be that causes that person to go free.
And you know, now that you talk about dismiss and you mentioned discharge, evidently there is a marked difference between the two. Care to elaborate on what those are?
Well, basically, when someone is discharged, more or less, we will say we would have failed. Failed in a sense to establish a prima facie case, that's to establish a concrete case or to put the relevant evidence before the court. So we would have failed to do that, and hence the matter would be discharged for insufficient evidence. So there's not enough to hold the offense that is before the court. And on the other hand, it will be dismissed if we would have completely embarked upon a trial and at the end the evidence is still not sufficient, so the person is literally found not guilty. So the dismissal has to do with us going through the entire trial and the person is not found guilty by the court. And the dischargeal is where the evidence lacks.
Lack of evidence, so it's discharged. And maybe some of those are some of the cases that you're talking about where maybe new evidence may come up within a period of time where you can then rearrest and recharge someone.
But
Correct?
within a specific time.
Within a specific time, yes. All right. Now, evidently, we hear sometimes a prosecutor, when someone stands up and they make a plea in court, an accused, or they apply for bail, a prosecutor stands up and says, we are requesting that this person not be granted bail based on the severity of the charge or other pending matters and those kinds of things. Or in some cases, a person may ask for bail and the prosecutor does not object to that request. What determines that?
Well, if we look at things like the person having a fixed place of abode, we know their addresses, they're known to the police and stuff, so it'll be easy for us to get them. We look at the severity of the offense because the offense might be one that might have time. When we say time, we talk about time in prison. And the person might be scared, and if the person is granted bail, the person might escape and not return. So we look at the magnitude of the offense, whether the person have a fixed place of abode, whether the person will tamper with the prosecution's case, like as in to scare the the virtual complainant or any of the prosecution's witnesses, whether the person will jump the jurisdiction or all of these things. All of these things basically are on hunch. Sometimes we don't take the chances when the matters are of an indictable nature. We would prefer that the person have a speedy trial and they're incarcerated or remanded while that process is happening. So if we have these hunch, and sometimes it's not just hunches, we have proof. They probably would have been in the system before and they did it before. So we bring these situation to the court and the court will remand them or not grant them bail. But bail is just basically a surety lodged in order so that the person can return to answer the charge. So sometimes, even if the magistrate is going to grant that person bail, we ask that it be done in a substantial amount so that that person can return. Because if it's a meager amount of money, sometimes they just walk away. But if it's a large sum, they return for that. So we take a lot of things into consideration before we would approve to the bail. Because sometimes they're living in the same street with the complainant, probably a few houses away, and we think that they might, obstruct our case in any way, scare our witnesses away, because we've had instances where people would have came to court and would have wanted to change their mind, I'm not going to go forward or whatever. And then when we get to the bottom of it, it's because persons tampered with the complainant or with the prosecution witnesses, and those things would weaken our cases more or less.
All right. And this thing about substantial bail, sometimes someone would have texted to ask how it is that for the very same offense, there it is that one person could be granted bail in a meager sum, whilst another will be granted bail for the very same offense in a substantial sum. And they're considering that this is unfair justice being meted out to them. What would you say about that?
Well, it's not necessarily unfair. It's what is granted by the court or what is granted by the magistrate. In some instances, let's say like the magistrate is setting bail at $50,000, and that is the standard limit for that offense because every offense carries a ceiling upon bail, right? So you wouldn't go for this amount or it's this or this. So when the ceiling is set, one of the defendants, just in order to have his or her liberty, they would say to the court that, Madam, I'm kind of short of 5,000 at this point in time. I just have 45,000. So it depends upon that. Consideration is also given because they might be short.
Okay, all right. So depending on that, so what goes to me should not necessarily does not necessarily go for you or the other person, and people should not necessarily just be looking at what happens with other persons, their circumstances, but they should be able to deal with their own circumstance. That's what you'd say.
Well, what goes for one person goes for all, but then with an explanation and a logical explanation, persons might be a little sympathetic to that situation, and then you might be granted some leverage, but it's not always that way. It just happens to be some lucky days for some lucky people.
All right. Someone is asking a question. When you hear about presuming of innocence in court, what are we talking about? And they go on to add that, of course, bail is one's constitutional right. Isn't the same to be given to them?
Well, in terms of bail being a constitutional right, that is so, like I said. Bail is granted in most summary offenses. It is granted in most summary offenses, but if it's indictable offenses, murder and stuff, it's a no-no.
It's a no-no.
Yes. You asked a second part of the question.
Or that, the whole presumption of innocence part. Yeah.
Presumption of innocence is just us being fair, not being biased to situations. So as soon as we see somebody and something is being said about them or something is being put out there, we go with an open mind. So this man is either guilty or innocent, but it's not for us to decide instantaneously. It's for us to embark upon a trial and depend upon the evidence that is being adduced within the court of law, then the determination is made. So as we look at that man, we presume that he's innocent until the facts and the surrounding circumstances say otherwise.
All right. it has certainly been a schooling exercise for me, and I'm quite sure it's been a schooling exercise for many of the persons who have been in tune, both on online as well as right here live on VOG's 102.5 FM. Just before you go, I want to ask you this final question. You alluded to it when you spoke about the AJA, Administration of Justice Act, and so on. If you can elaborate a little bit on that as you tell us about the different types of trials that can occur, or a person will be made to stand.
Well, basically, we have two types of trials. We have civil trials and we have criminal trials. We don't deal primarily with civil trials. We deal more with the criminal aspect of the trials. And the HAA, because the civil part of it, it deals with claims. Claims when something would have gone wrong, somebody would have damaged property, different things. So the civil part kicks in, but the criminal part is when somebody would have literally been hurt within the system, and the criminal part of it takes aspect where we come before a judge, a jury, or a magistrate in the lower court, and they will determine innocence or guilt.
All right. In terms of the execution of duties within your district, how confident have you been, and what would you say your success rate has been for the first part of this year? Of convictions, that is.
Well, we've had quite a few convictions. We've had some challenges with the COVID aspect of the cases because of the jurisdiction issue, because people would be out in one jurisdiction when they're from a next, and sometimes they would provide incorrect addresses and stuff. But we've had a handful of conviction, and it's why I'm saying a handful and not a whole lot. Because of the COVID situation, we've not been operating like we used to, like we should, at the same pace, at the same number. At first, we used to do hundreds of cases in one day, and now we're limited to 25. And then with that 25, if there's about 15 or more witnesses, sometimes we're just confined to two or three per day. So the convictions are taking a bit longer. Sometimes it's slow, but it's sure because we have more time to go through what we're doing, and we have more time to be familiar with what we're doing and familiarize ourselves with our cases and our witnesses. We're having difficulties in summoning them, getting across the board, getting them to court. And because of the COVID, most people don't want to come, they don't want to interact, and that is where the virtual part of it is helping a lot. So the conviction rate for this year for me will be a number of 119 for summary offenses. And the last I checked, which was a few weeks ago, I had about 54 indictable convictions.
About 54 indictable convictions.
That's for the entire year.
For the entire year, and 119 summary.
Summary. That will count for all the small matters.
Awesome. Your final words, what would you say to those persons who've got cases, both accused as well as virtual complainants, who feel that because of the time that we're in, as you did mention, and the slot, oftentimes people get suspicious, right? And then they want to say, well, you know what? It looked like these people are cook up this thing or what's not. Not understanding some of the semantics that you did mention, some of the difficulties that we have. What would you say to residents within that division who will have matters before the courts?
Well, basically, I'm just asking you to be patient with us. It's better to have slow justice than no justice at all. And if there's some level of suspicion or concern, my office is always open and I can try to explain what the situation is, because I have had a few complaints because they're uncertain what is happening. They said the police is not communicating sufficiently, among other things. So I will try to explain to the best of my knowledge, as in, your case is there, it is secured, you'll have the relevant justice because we have the evidence. I'll try to reassure them that it is better to have slow justice than no justice at all. So just bear with us. We are working and taking into consideration the pandemic, taking into consideration the geographic location, taking into consideration the availability of the prosecution, among other things, because I've had a few prosecutors who were down by COVID, and hence they were away for quite some time. And sometimes it's difficult for someone new to just come and pick up cases and go with it, unless it's a real fast-paced prosecutor, or like you would say, the more experienced ones. They will come and they can go forward with a case that is not quite familiar to them.
Awesome, awesome. Well, tonight has certainly been a learning night for all of us. I want to say thanks very much for spending some time on the police and you with us tonight, Assistant Superintendent Shavon Jupiter. It's been a pleasure having you here, and thank you for all of the knowledge that you would have shared for particularly your Regional Division 4C.
Thank you very much, sir. Thanks for having me.
As on our Facebook and our YouTube page. A big thank you also to our camera crew here at NCN Bishop. We also say a big thanks to the streaming boss, Mr. Brown, and our production team, Noel and Raj Bali, who made sure that everything was possible. Thanks for joining us, and do enjoy the rest of your night. We now join the news in progress. I'm Stan Gavai saying goodbye.